exists between the police department and Montgomery County State's Attorney's Office. Look, I began thinking about this, Brad, when we were coming here, is that DNA really started here. If you go back and you look at the history of DNA, there was one DNA lab in the United States of America. It was Cellmark Laboratories. It was on the campus of Montgomery College here in Germantown. I'm going to that campus this afternoon for a presentation with, so, I mean, I've been in those, when they were in those small little labs. Before O.J. Simpson occurred, I was working with all those same people here, and I'm proud of this office for what they did to help break through and help develop the use of DNA, and the fact that we are continuing to push and use tools that are available to us that can bring some solace to these families. Look, it doesn't bring Leslie back, but now they know what happened or who did it to her, and I think they're, there's no such thing as closure, but it's, I'm proud of what we do together, and I'm proud of our continuing search to find creative ways to make people in this community safer, and we did it in this case.
I mean,
you've heard that this helps.
yeah,
Yes.
If they're sentencing, I'll tell you well, but as of now, I'm willing to look at this from the family with Brad.
Yeah, I think it's pretty clear, and I think it's pretty clear. We were talking to family members upstairs, and Mrs. Pruitt's sister is here. What word would you use? The fact that it's over. I'm searching for them to give me a word. If they could sum it up for you in a word.
What are you looking for?
What?
Wonderful.
Look.
Justice.
Wonderful. These are look. They're calling out words behind me, and that's how they feel about it. They feel it's justice. It's wonderful that this has happened, and to have this mystery finally solved for them as to who took this wonderful woman from their life. It's important to them. Right. Well, first-degree murder is premeditated murder, and again, without knowing exactly the reason he went. Look, if somebody goes in, hypothetically, and is in the middle of committing a theft or a burglary from a house, and they're surprised by an individual, it's very hard to establish that a person necessarily premeditated the killing. Now, I will tell you, this was a blunt force trauma case. There were multiple injuries. But we've discussed this with the family internally, with some of the difficulties of going to trial and whether there would be a likelihood of a first-degree conviction. I think that everyone who looked at this case felt that second degree, which carries 30 years in prison. The defendant himself, by the way, has no criminal record. Now he's 44 years old. He doesn't have a criminal record. There may have been some issues in his past when he was a younger person, based on my knowledge of what he was doing back then. Again, assuming that there was no evidence to suggest it's premeditated. It's something that appears to have been a spur-of-the-moment thing that occurred, which leans more towards second degree. All murders are presumed to be second degree. Premeditation would have been a difficult thing to prove in this case. We were satisfied that a 30-year exposure was an appropriate way to resolve this, and the family agreed.
Mr. McCarthy, did the plea deal does it require you to allocate within the guideline range, or are you free to ask for anywhere in that 30 years?
Thank you for that question, and it's a great question. We are free to ask for the statutory maximum. The penalty for second-degree murder today, if anybody Googles it, it's 40 years now. But when you commit a crime, you have to look at what the statute and the statute of limitation, or not statute of limitation, what the maximum penalty was at the time. It was 30. So because we go back 25 years, the maximum penalty is 30 years. That's what the penalty was as it existed on the day he committed the murder.
Can you talk a little bit more about how your office balanced privacy concerns from the need to show the judge about law enforcement exigencies here with using this DNA, which you said is first, but presumably not the last time your office was used?
Well, we've actually had other cases, quite candidly, there have been other cases where we've used DNA evidence and identified the perpetrator, and during that perpetrator did not survive the arrest in that case. Not that I'm aware of. No, not at this time.
Sir, I just want to talk. Can you talk about what you need to show the judge to get access to this familial DNA database in this case?
Exhaustion, basically. You have to basically go through and give a 20-year summary of all of the tactics that were used, and I guess Chris, who heads that unit, I'm sure that they have to go through and basically show that they've exhausted all other reasonable avenues of investigation. So it's sort of a last resort. These limitations were established by the legislature in Maryland. The limitations we have are different than some other states. In some states, familial DNA is more readily usable. In others, there are greater restrictions. There are a tremendous amount of privacy interests that are involved in the use of DNA evidence, and that's why I believe the legislature put these checks and balances involved. The same thing is true. Look, we're not unfamiliar with exhaustion. If I was going to get a wiretap on someone, I have to show exhaustion to get a wiretap. If I want to get a search and look at familial DNA records, I now also have to show. It's a standard we've used in other contexts. Not the first time we've had to deal with exhaustion as a standard. We do it for every wiretap case. Okay. Donna, you want to come up? Wait, Donna, why don't you come up here?
Good morning. It's Lauren Preer, who's Leslie's daughter, her only child. And then she had 7 siblings, many whom were on the Zoom today. But in person, it's Robin and Kevin Haney, and Robin is Lauren. I'm sorry, Blair. I apologize. The other sister, Bob. Blair and Kevin Haney are present here today. And we anticipate that many siblings will be present in person at sentencing and provide both written and talk to the judge and advocate for what they feel is an appropriate sentence in this case.
Okay. Thank you very much.
I'm so sorry. I had Robin in my head. We only found it 3 times today. I called you, Blair, 6 times.
Yeah.
Thank you. Okay. Thank you. Come back to see you again.
Yep, this is my co-pilot.
Excellent.